Good morning and welcome to HR Issues and Your Ministry during COVID-19. My name is Bob Brockman. I'm an attorney with Daley and Heft in Solana Beach, California. I have, over the past 25 or more years, specialized my practice in representing nonprofit religious organizations and have worked with the insurance board for many of those years. Today with me is Leslie DeMattia from DeMattia Consulting. Leslie, would you say hello?
Hi, everybody. Glad to be here.
Okay. Leslie also does lots of work with religious nonprofits. Leslie and I often work together on different matters for different churches and other religious organizations. Before we get started this morning, Leslie, I wanted to thank the insurance board for inviting us to speak with you today. You know, as I mentioned a moment ago, I've worked with them for many years. They are a group of people that are certainly very much dedicated to the members that participate in their various different programs. They provide great products, great services. If you haven't been in contact with them much, I would strongly encourage you to do that. You also might want to look at the different resources that they have available at www.insuranceboard.org. They have a number of resources, many of which are brand new to help you get through the COVID-19 crisis. And Leslie, I know that you know that the insurance board is located in downtown Cleveland, but what you might not know is that I have a strong personal connection to Cleveland. I spent about 3.5 years there when I was an undergraduate student and actually worked for a short period of time just a block up the street from the insurance board's current offices downtown. So I'm always glad to get back there. I always have great memories of that. One of the things you definitely need to see, and I'll always pitch this, if anybody is anywhere in Cleveland or anywhere near Cleveland, you've got to go to the Rock and Roll Hall of Fame. It is absolutely fantastic. I've been there several times, and every time I'm in the area, I love to go back there. As a matter of housekeeping, Leslie, I understand that there's a chat feature that we're going to be using. Could you explain that?
Yeah. So if you're not familiar with chat, you can actually type in questions, and we're going to be answering those questions live today. We're super excited to be here. I'm assuming that you are watching from home. Most of us are quarantined, or what we call in a stay-at-home order, and we are at home too. This is my home office, and we're excited to join you in that stay-at-home, keep healthy and well order. So please remember throughout our presentation to use the chat feature, and we'll be happy to answer the questions as we go along.
Today, we're going to be talking about a variety of different human resources issues that really, in large part, have only come up in the last 30 days or so. As I mentioned, I've been representing religious nonprofits for a long time, but certainly the landscape has radically changed in the last 30 days. So we're going to try to go over different issues that our clients have been asking questions about, issues that they are struggling with, matters that have come up that they are dealing with. I want to remind you as we get started, though, that the information that we are presenting today is not intended to be legal advice or take the place of professional human resources advice. So it's very important that if you need specific legal advice or human resources advice, that you get that in the jurisdiction, in the state in which you live. As I mentioned a moment ago, Leslie and I are both in Southern California, so we're going to try to give you concepts that we believe would apply wherever you are, or at least raise issues that you need to consider with respect to your specific state. So sometimes we may give an example that is unique to our situation, but it's intended to raise that issue so that you will have that in the back of your mind and can address that in your particular jurisdiction. Leslie, have you seen churches and ministries struggling with unique issues in the last couple of days?
I think so, Bob. This is such an unprecedented time, and Bob and I together are actually trying to keep a little bit ahead of the game as laws come out, as new programs come out and as we try to help our ministries continue to do what they need to do while trying to um, stay their ministry so that they can continue to do ministry, and so that when all this is over, and praise Jesus, hopefully it'll be over soon, but they can actually step back into ministry and be able to minister to those that they serve so well. So we're praying for you. We're super excited to be here. And Bob, your lighting looks so good.
Leslie and I have worked together many times in the past, and she's always knows that I'm a little sensitive when it comes to lighting because I tend to get a little bit more shine on the top of my head than she does. So anyway, we'll try to ignore her little digs here and there. But we're going to try to focus, as I said, on things that keep coming up with the different organizations that we work with. Certainly, when it comes to human resources issues currently, one of the primary concerns is in controlling costs. And a lot of it is, what do we do with personnel at this point, given the expense that is created by staffing, and how do we go about reducing those costs? So a lot of the issues stem from the underlying issue that we need to control costs during this difficult time. So one of these topics that we have talked about a lot with clients recently is reducing hours. Leslie, have you had clients come to you and ask if they can reduce hours of their staff?
Yes, I think that it's actually something that's happening on a very frequent basis. I know some people delayed that a little bit, and now they're starting to reduce hours and or lay or furlough people off, which I know we're going to get into later. But I think this is a really critical area to maintain costs. And let's dig in with non-exempt and exempt employees, Bob.
Sure. Let's talk about non-exempt employees, or what some folks refer to as hourly employees. Can you reduce the number of hours that they work? And the answer to that is certainly yes, you can do that. You can do that under a number of different scenarios. In particular, I think it's important to give individuals notice ahead of time that the hours in which they are working are going to be reduced. That is particularly important in a state like California and some other states which have specific requirements with regard to schedule changes. If you don't actually change someone's schedule when you reduce their hours, or notify them that you are reducing their hours with a schedule change, and rather simply have them come into work and then tell them that you don't have enough work for them that day and send them home, then you're running the risk that you're going to pay what in our state is referred to as reporting time pay. In other words, there is a provision in our state statute that says if you tell someone to come in, they normally are scheduled, as an example, to work 8 hours a day. You have them come into work and then you tell them we don't have enough work for you that day. You will have to pay them for the hours worked. Plus, you will have to pay them a number of premium hours on top of that, that is referred to as reporting time pay. Employers can avoid that, can't they, Leslie? And how do they go about it?
Sure. They can avoid that by sending out a notice and letting the employee know that they're going to be changing their schedule. And with non-exempt employees, employers have the right, Bob, if you can correct me if I'm wrong, to change a schedule as needed. One of the things I want to make sure that employers are doing though is referencing COVID-19. Hey, due to the fact of these unforeseeable circumstances, we have to change your schedule. And the reason we're changing your schedule is as a cost reduction. And you will be notified, and tell them, like, if you're going to change your schedule weekly, or if you're just going to reduce hours on a temporary basis, like somebody's going from working 30 hours and now they're going to work 10. You could just make sure that you disclose what those schedules are going to be like, either moving forward or on an as needed basis, or for a period of time. Right, Bob?
Yes, Leslie, I want to point out something too. You indicated that it was important to tell them, and we're telling them from a legal standpoint why it's important to give someone notice that their schedule is changed, because that way we avoid in some jurisdictions these penalties that may apply or premium hours that may apply if you don't. But also, I think I want to echo one comment that you made, that it's very important to let people know ahead of time that this is COVID-19 related. Very oftentimes in our work, we see employees who are also members of that congregation. So, in addition to a normal employer employee relationship, there's often an emotional attachment. Do you see that, Leslie?
I do. And if you've worked for a church or a ministry or a school or a camp or any
Mm.
nonprofit religious organization for any length of time, you know that it's not just a workforce, Bob, it's a family. And this is affecting the family, the church family, the ministry family, the school family, and it's hard. And so there is a lot of communication that needs to go into this and thoughtful, planned out strategic communication in order to dispel fear, in order to make things clear or make sure that there's clarity around why you're doing something. And I think it's just paramount right now that organizations are communicating clearly in order to create as much stability and calm as we can during this time.
I definitely agree with that. One of the other issues that sometimes comes up is some of our clients have employees who are in an on call status.
Mm.
And again, if you have employees that are available on call, you may want to notice them as well that there is a change in their on call schedule. Because again, if the person is on call during periods of time when they are actually not needed to be on call, the ministry is going to pay for that time when in fact they could save a substantial amount of money by perhaps reducing the scheduled on call period of time for an individual, since they're no longer needed to be on call as much as they had been in the past. So I think that's a very important thing. Uh, I know, can you talk a little bit, Leslie, about benefits for non-exempt employees? I think that's always a consideration when we're reducing hours. Would you agree?
I do agree. And there is a threshold as far as Obamacare or ACA and when people get benefits. But I know that insurance companies are working diligently right now to address some of that. But what I would encourage you to do is to contact your plan provider. We've seen some things out here in the West that are pretty encouraging where providers are allowing, if you use certain terms, to keep people on your health insurance. And there's also, which we're not going to talk about in depth today, but with the CARES Act and some of the FFRCA stuff, there are benefits available or at least accessible, which was covered on some other webinars on the insurance boards that are posted on the insurance board's website. Is that correct, Bob?
That's my understanding as well. I would strongly encourage you that if you haven't seen those other webcasts, take the time. They'll be well worth it. I've watched one of them and almost the entire second one so far. So I strongly encourage you to watch those. I think it's some really good information. And again, you can find those, if I'm not mistaken, at www.insuranceboard.org.
Awesome. Yeah, I think you need to contact your plan providers and to ensure that you're not unnecessarily cutting somebody's benefits, or if they have a special way or some type of plan that you can continue benefits for people. I know right now most ministries are doing everything they can to keep their employees insured and covered with health insurance. So please reach out to your plan providers and get that information directly from them.
Right. Um, let's talk a little bit, if we can, Leslie, about exempt employees. There is a critical distinction here when we talk about reducing hours. There's this huge distinction between non-exempt and exempt employees, correct?
Absolutely. So do you want to go a little bit into the difference between non-exempt and exempt employees just to cover a little definition of that, Bob, before we jump in?
Sure, sure. The concepts of an exempt and non-exempt employee comes out of the Fair Labor Standards Act. As you know, under the federal law, the Fair Labor Standards Act, all employees who work more than 40 hours in a week are entitled to overtime. There are a whole bunch of other provisions under the Fair Labor Standards Act apply as well, but that's the basic one that most people are most familiar with. So the law states that if you work more than 40 hours in a week, you are entitled to overtime. So it's very, very important with regard to a employee who is entitled to overtime to keep accurate records of all hours worked. Then, under the Fair Labor Standards Act, there are certain categories of employees who are exempt from overtime. Those individuals may fall into what's called a professional exemption or administrative exemption or several other exemptions that are set forth in the Fair Labor Standards Act. The primary biggest distinction from our standpoint is that those employees are what is commonly or sometimes referred to as salary employees, but they have both a duties test and a salary test in order to be an exempt employee. But those individuals are exempt from the overtime requirements. Those are the basic distinctions between the two. The important thing when we are looking at reducing someone's hours, when we talk about an exempt employee, is to keep in mind that someone who is exempt in their status, it is assumed that their position is based on full-time employment. Correct, Leslie?
Yeah, Bob, one of the things I like to say, and this is not official language, legal language, is that in ministry, to be considered exempt, you are so highly paid that we don't really have to track your comings and goings or your overtime that's worked, which is really kind of funny because most people that are in ministry are not really highly paid. A lot of it is pure service, but that's kind of how I like to look at it. You're so highly paid that you're paid this enormous amount of money that covers all your overtime, all the time you work.
The law has the assumption that an exempt person is working full time. Full time generally means 2,080 hours a year. But one of the most important things that we always need to remember when we're like trying to control costs, when it comes to an exempt employee, if that employee works at all, any period of time within a pay period, then the exempt employee is entitled to be paid for the entire pay period. So if the exempt employee only works on Monday or only comes in for a couple of hours on Tuesday, that exempt employee is entitled to be paid for the entire pay period, even though they only worked a very short period of time, which often raises the question, can you have a part-time exempt employee?
Actually, there really is no such thing as a part-time exempt employee. However, you're not really tracking when they're coming and going because they're paid to do a job, right, Bob? Okay, so
Right.
if you're paid to do this job, um, then you could get that job done in 30 hours. You could get that job done in 70 hours. It doesn't really matter. Is that correct?
Sure. So while we don't technically have a part-time exempt employee, we may have exempt employees whose salary and job is based on 2,080 hours a year. But for whatever reason, they work far less in one week and far more than others. I'm sure in your position, certainly in mine, there have been many times in my career where I've worked a very limited number of hours in a given week, and the following week, particularly if I'm going to trial or something like that, I'll be working 60 65 hours a week, maybe more than that if needed. The important thing always to remember is when we're looking to reduce hours to reduce costs for a ministry, that we can reduce the hours and reduce costs with respect to a non-exempt employee. But when we're looking at an exempt employee, if that employee works at all during a pay period, they are entitled to their full pay. So looking to reduce costs by reducing the hours of an exempt employee probably really isn't feasible. What happens, Leslie, if we do start limiting the hours or decide to limit the hours of an exempt employee? Can they become non-exempt?
Absolutely. And I think in this time frame, it's probably a good idea if you're going to be reducing exempt employees' hours and maybe they would fall below whatever state salary limit or compensation limit you have, that you notice them, that you're going to be moving them to a non-exempt status. Bob, I just had a quick question as I digress. Any chance that you've been working a lot during this time? So you said sometimes you work a minimal amount of time. I was wondering if COVID-19 has increased your workload at all.
I know you know the answer to that, Leslie, because when I called you to touch base with regard to this program, when I called you last night, you were exhausted. It was, I don't even remember what time was. I was absolutely exhausted, but I know we've been working overtime like crazy to try to help with this. And many of the ministries that we are working with, certainly their HR folks, and it may be somebody who is an actual HR professional that works for a church or other type of ministry, or someone who does other things in a smaller church and is left with that function. They certainly are working like crazy during this time. Um, but when we talk about exempt employees and the possibility of reducing hours, I want to be clear too that with regard to exempt employees, if there's going to be a reduction in hours, again, contact your benefits provider and make sure that you're always complying with the benefits plan so that you don't get outside of that. Another issue that I haven't seen it come up much yet, but it's certainly something that we want to consider. And it's come to my attention recently with one of my clients that's a large organization that had a very large layoff of employees, and a religious organization up in the Los Angeles County area. They had to lay off quite a few people. And also, when I was doing some research on the internet, I got a pop-up from a law firm in LA. It's on Wilshire Boulevard. They're all on Wilshire Boulevard looking for employment law cases. But one of the things that came up there was a specific notation on their website that they are looking for cases involving COVID-19, looking for cases involving emergency FMLA and how that's applied, and hours and wages and all of those kinds of things. So we certainly are in a position where the plaintiff's attorneys are looking to see if there have been violations of these things. And I'm sure that this is occurring in every state across the country. So when we look at exempt employees, please keep in mind that they are going to be paid the same whether they work one day or whether they work their full week. Another area that I noted on that plaintiff's attorney's website, and I wanted to bring up anyway, is when we are reducing hours, whether it is a non-exempt employee or we're considering reducing the hours that an exempt employee is going to work and perhaps transition them to becoming non-exempt, we want to make sure that we are doing it in a non-discriminatory manner. So if you are having a reduction in your workforce, please be able to at all times articulate objective criteria for that workforce reduction. Oftentimes we see workforce reductions, particularly in larger organizations, where the objective criteria is simply that we are going to eliminate X percentage of people in each department, and that we are going to eliminate or reduce the workforce by the most recent hired individuals or some other objective criteria. So if we have a department that because of COVID-19 isn't going to be operating for the foreseeable future, reducing a workforce in that department would be an objective criteria. We do not want to be in a position where we are reducing our workforce and we just happen to get rid of all of the people who are over 40. as an example, because we're setting ourselves up for age discrimination cases.
Bob, let me ask you a quick question. So, at my fictional church, we have a bunch of employees that were really substandard employees. And because we are a church and we were kind, we were giving them a lot of time to get their performance, their behavior up to par before we said anything. And so now our senior pastor, as we look at laying people off, wants to lay off all of those people first. And it's random throughout the organization. We have 6 or 7 employees that are really shouldn't be working there anymore because they're not able to fulfill the requirements of their job. Can we just lay off those people first?
You can lay off, to answer your question, frankly, yes, sure, you can lay off your substandard people first. But again, you had better be able to articulate specific reasons why this person's performance is substandard or less acceptable than someone else's. What we often see as a problem, and I'm sure that you have seen as a problem, is the ministries that we represent oftentimes do not want to, it's against their grain to be critical of individuals. They don't want to be critical of people. So even when we look at the performance reviews that they've done, we see a lot of grade inflation. And sometimes it's because they don't want to be critical. Sometimes it's because they don't want to be demeaning. Sometimes it's because they are hoping that by giving a person a better performance review, that that person will do better in the future, whatever the reason. However, it does create a problem now if you are then going to go back and say, well, this person's performance really wasn't that good compared to this other person. Therefore, we're going to have to let person A go because they're not performing as well. If you don't have objective criteria or objective evidence to back that up, that could be a much more difficult sell down the road. So keep in mind individuals that may fall into protected classes. We do not, in our layoff process, want to be creating more problems or even in reduction of hours of work. We don't want to be creating exposures to liability. Leslie, can we talk a little bit about reducing rates of pay? We've talked about reducing the hours that somebody is working. Another cost-saving measure is the possibility of reducing someone's pay. Have you seen that come up?
Sure. I think a lot of employers are doing that. I've seen a bunch of ministries that just decided everybody's going to take a certain percentage of a cut. I've seen people go through and like this category of workers is going to take this much cut or that much cut. But that can pose a little bit of a potential issue for exempt employees. Is that not correct, Bob?
It can. Let's talk about the non-exempt because I think they're the simplest first. Do you want to
Yeah.
address that one first?
Sure. I think you just have to notice your non-exempt employees that you're going to be reducing their level of pay, and make sure that they know when that's going to take effect, how much you're going to cut their pay. And again, I want you to state the reason that you're doing that is because of these unforeseeable business circumstances due to COVID-19. Did I miss anything, Bob?
No, I don't think so. The only thing, again, I want to remind you, do it in a manner that is across the board, even-handed. I had one or more clients that indicated that they wanted to reduce the pay for individuals who were not married and didn't have kids because they felt like the married families with kids needed the monies more. I would caution you against that. I have respect for them in that they want to provide for families and it's their heart that may be in the right place, but they can be opening themselves to discrimination claims there. So have objective criteria if you don't have an across the board reduction in pay coming. But I think non-exempt employees are probably the easiest to deal with on that particular issue because they are paid for the number of hours that they work. You simply reduce their pay and perhaps at the same time reduce the number of hours worked. But with exempt employees, we have to meet, as we alluded to a few minutes ago, an exempt employee, in order to be exempt, must fall into one of the federal categories that specifically defines what it means to be an exempt employee to start with. And then that's what they refer to as the duties test. You have to meet certain duties to be exempt. And then they also have to meet a compensation test, correct?
That's correct. I just wanted to remind everybody as we're walking through this, if you have questions, make sure you use the chat feature. We'll be happy to answer those questions. But Bob, you are correct. As far as an exempt employee goes, there's compensation requirements. And Bob referred to the Fair Labors and Standards Act and your federal requirements. But each state, if I'm not correct, may even have more stringent circumstances where you have to provide. I know New York and California are that way. So make sure that you're checking with your state for your minimum salary requirements. Now, Bob, if you are going to cut an exempt employee's salary or their compensation, and it goes below the minimum dollar amount that is required to keep somebody as exempt, what do you do?
They've rolled over and become non-exempt.
Okay.
So unfortunately, when we look at the test to be exempt, there is both the duties test and the compensation test, and they must meet both. So if they are going to fall below the threshold compensation level on the compensation test, then by very definition, they are no longer an exempt employee. Thus, they become a non-exempt employee, which means that their new rate of pay is converted to an hourly rate of pay. And the concern there is always that if they work any overtime, that they are going to be entitled to overtime. Under federal law, it is more than 40 hours in a given week. So under the federal law, you could work 4 10-hour days and still not go over the 40 hours in a week and be entitled to overtime. Under state laws, the various states, many of them, have changed that program, and they'll say, as an example, that you can't work more than 40 hours a week, or you can't work more than 8 hours in a day, even if you don't work 40 hours a week, and you'd be entitled to overtime. So if you have an exempt employee who is going to take a pay reduction that drops him or her below the threshold to be an exempt employee, then they by definition have become a non-exempt employee, and then you need to be concerned about the number of hours that they are working. And just so that everyone knows, under the Fair Labor Standards Act, there are a whole variety of different subcategories, but generally speaking, in the vast majority of them, an exempt employee, in order to be exempt, needs to be earning $684 a week, which is $35,568 on an annual basis. But many states, such as ours, have adjusted that, and it's substantially more. So make sure that before you automatically reduce the pay for an exempt employee, that you give consideration to compliance with the threshold requirements for compensation.
Bob, I had a quick question for you. If we have an exempt employee that, because of our salary or compensation reduction, is now a non-exempt employee, and I know you cautioned that they might be eligible for overtime, can't we have a policy that says in order to work overtime, it must be pre-approved?
Not only can you have that, I would strongly encourage you to have that. Over the years, I'm sure you've had the same situation, Leslie. We have had many wage and hour claims stemming from religious organizations. And I often am faced with a pastor who can't believe that this now former employee would make such a claim, because this former employee at the time was so devoted to the ministry, seemed to have the same mindset as the ministry, seemed to have the same goals as the ministry. And the ministry was interested in getting the work of ministry done and was not worried about how many hours it took to do it. That was all secondary. Sometimes, unfortunately, as I say, the relationship goes bad. And unfortunately, when it goes bad, sometimes it goes really bad. And then we have circumstances where these now former employees will make claims, and they are individuals that we thought were part of our church family. They have now left the family for sure. And they are making claims that they are entitled to overtime for quite some time back. And unfortunately, in many cases, we don't have documentation of the actual hours worked. So I strongly, strongly advise you to keep accurate records of all hours worked. It is very, very important, particularly in the COVID-19 environment where we have people that are telecommuting, and we'll address that again in just a second. But oftentimes when an exempt employee's salary level is reduced such that they don't meet the threshold requirements for compensation and they become a non-exempt employee, sometimes we're not thinking that we need to keep records of all hours that that person worked, and we absolutely need to do that.
Right. I agree. I think one of the things that's hard for an exempt employee is to move to a non-exempt position because they're not used to tracking their time. So one of the things that I recommend, Bob, is that when you notice them that their hours are reduced or their compensation is reduced and they're going to be a non-exempt employee, I always like to give them a sample time card. I like to show them how to fill it out. Or if you have some type of electronic digital hours tracking timekeeping system, to kind of walk them through how to do that. And I think most people right now have a kind of can-do attitude where it's like, hey, we understand this. We understand that we are going to be a non-exempt employee. And I don't think overtime will come into play very often unless maybe you're in California and you're filming Sunday service to go online and it goes over 8 hours. But I do want you to make sure that you're checking with your state's guidelines as far as compensation. In California, it's $54,080 if you're 26 or more employees, and if you're below 26 employees, it's 49,920. That's a lot different than the federal standard of 35,000 whatever, right, Bob?
That is absolutely correct. Yes.
Right.
One of the ways too, in dealing with his conversion from being an exempt employee to now being a non-exempt employee that has to keep track of their hours, you may want to also remind those employees, I would think, as a matter of good human resources practice, that the church definitely wants to comply with the law, that we want to do a really good job, and we want to make sure that all employees get paid to the fullest extent that they're entitled. So we want to make sure that you keep accurate records of all of the time worked so that you get paid for the time that you're entitled to be paid for.
Right.
And make it a positive.
I actually think right now there'll probably be less overtime, Bob, only because that's the whole point, right? We're reducing hours, we're reducing pay, people are working from home. And even the adjustment to working at home is a little hard for some people, and trying to figure out how to fill your time and what to do. Although there's many of us who are working extra. I'm not saying that many people aren't, but I think that the whole point of moving somebody to non-exempt is because they're working less.
Yes, and that brings us to our next topic, Leslie, which is telecommuting. There are a lot of considerations that go into play when we talk about telecommuting, having people work at home. And certainly, I think there's only the last I heard of the news, and it seems to change day to day. I think 7 states left that don't have stay-at-home directives to some extent. So we have a whole lot of people that are suddenly working at home. How about telecommuting policies, Leslie? Have you dealt with those before?
Yeah, we've been dealing with them a lot lately, actually. So it's kind of fun, and I think it's a really good area. And I think a lot of employers are learning that they can have their employees work from home, but there's some specific things we need to address when we look at having our employees telecommute. Okay. First of all, in some states, especially those that are not in what I call the lockdown state, they have employees still going to work. Okay. And when we first went into our sort of stay at home or social distancing, we were allowed to have essential employees still at work, but everybody else needed to be at home. And the law basically decided that certain businesses were essential and certain weren't. So now, previously, before this recent order in my county, we could go to work. We could go to work if we were what we called essential employees. Okay, now in my county, if you're not an essential business, and I think the federal government put out guidelines regarding that, like it has to be with commercial transportation, it has to be with healthcare. There's a whole list of those. But now, if you're not in one of those areas working, then you cannot be at work. So I want you to make sure you know your local guidelines before you jump in to making some people still work at the place of business. But let's jump into that, Bob. So first of all, we want to determine the circumstances that will be committed in regards to telecommuting. Like, is the employee requesting to work from home? Okay, maybe they need to care for a family member, or they want to do a social distancing precaution, or it's just in a reasonable accommodation due to a disability. But also, you can require your employees to work from home. And that's also to promote social distancing, or for an employee who's showing signs of illness. Or I just had this recently, an employee who came back from travel, and the employer required them to self quarantine for 14 days. So, what you want to do is you want to make sure that you identify the positions that are conducive to working at home. Okay. And you want to make sure that the positions can be regularly performed remotely. It may include some job duties that can be remotely and maybe others not. And we need to create that position so that you know what duties those people are doing. You also want to make sure that you know the positions that don't actually meet the criteria to telecommute. For instance, at my church, we have a whole facilities department. Most of those duties cannot be conducive to working at home. Okay. The other thing you want to do is you want to identify equipment that's necessary to work from home. All right. Now, some employees may have personal devices, and you may permit those employees to use those at home for business purposes. So they might have a laptop, they might have a iPad, they might have a home computer, which normally you wouldn't allow them to use those at home, but you can permit them to do that. You also need to determine if there's certain hardware or software or things that need to be purchased so people can use their home computers or their home digital devices. All right. The other thing you want to do is is there equipment in your organization that you could allow them to use at home? If somebody has a laptop, they can take it home. If somebody wants to take their desktop computer home, will it be conducive to working at home? All right. Bob, did you want to talk about any of this, or do you just want me to go through it all?
Sure. Yeah, just briefly, it's interesting, Leslie, because our churches haven't dealt with these things before. Many of them haven't adopted telecommuting policies or have telecommuting agreements for their employees and those kinds of things. So we will have available through www.insuranceboard.org sample forms for each one of these things, I believe. And you want to tell everybody what we have available, Leslie?
Sure. We have some short-term telecommuting agreements. We have a telecommuting policy. We have a checklist for emergency telecommuting positions, things that you need to think about, which were the things that I was just covering. So all those samples will be available to you, and we're super excited to get our heads together and provide those for you. One of the things I wanted to talk about in regards to development of a telecommuting policy is you want to make sure that you're addressing the new required timekeeping procedures from an at-home perspective. Okay, this will differ for different teleworkers, but you want to make sure that you're addressing what those expectations are and that you are expecting them to get pre-approval for any overtime that's worked. Some other things you want to talk about or think about for your policy is security for your remote workers. How will the information be kept secure? Are there certain specific things you expect them to do? Maybe how they save their work. Maybe it's on a network. Maybe they log in remotely to a network or have remote access. You also want to determine if you need a private network or anything like that, or if there's a portal that exists. But you want to make sure that you're communicating all of these policies to your employees and develop some type of telecommuting agreement for them, which Bob actually created your telecommuting temporary agreement sample. So that's something that will be really helpful to you. But it basically just addresses the fact that it addresses the COVID-19 situation. It addresses that they're either doing a voluntary or a required work from home policy. It talks about essential positions that may be required if you're in a state that you can still go to work. It addresses that. And then it also addresses that telecommuting will probably be on a case by case basis otherwise. Because let's face it, most of us can't afford right now to have all of our people telecommuting from home, but some of us are able to have many telecommute from home. And then there's an agreement that the employee signs to ensure that they understand the policies and the procedures around that telecommuting situation and that it's a temporary situation. And do you have anything else to add to those?
Just a couple of points that I wanted to echo that you've brought up, Leslie, that I think are extremely important. You mentioned a telecommuting agreement and a telecommuting policy. They have to have in there, in my opinion, a provision that says that when it's time to return to the office, that the employee is going to do that. Because sometimes the employee is thrilled to death to be able to get to work at home, and in many cases that may not be what is in the best interest of the organization from a business management standpoint. So that needs to be in there. You also mentioned keeping track of an individual's hours when they are working at home. This is very, very important in many, many jurisdictions, not just ours. But I can give you an example. I was talking to a pastor uh, earlier this week that has employees who are working at home. And the suggestion was that their payroll department should just mark down the number of hours that they usually work on a given day and use that as their payroll record.
Well,
And that definitely is not acceptable. I can tell you, you agree with me on that one, Leslie. You
I
need
do.
to develop a system, whether it is electronic through their computer, whether it is handwritten, where they are marking down their start time in the morning, the time that they are, quote, clocking out for lunch, the time that they return from lunch, and the time that they finish at the end of the day. All right. We also should include at the bottom of that a statement that the hours as recorded above are accurate and reflect the accurate hours that the employee worked, and have the employee sign each one of those. They usually do this on a weekly basis. But it is very important to protect ministries from overtime claims. Um, and sometimes a lot of penalties that go with it for not paying an employee correctly. It's very important to have accurate records of all hours worked.
Yeah.
Many jurisdictions, by statute, require that employers keep accurate records of all hours worked. And when you have employees working at home, things seem to be much more lax, but this is one area where we definitely have got to tighten things up and make sure that we're complying. Would you agree with that?
I totally agree with that. There's a couple things we didn't talk about that I wanted to raise as an issue, and those are cybersecurity and intellectual properties. So normally when you create a product at work, because it's at work on on work computers, on work equipment, anything you do during that time is considered the employer's product. Okay. So what I want you to do is you're creating your policies and things like that. I want you to think about this. If you're allowing people to use their home computer or they're working from home, we need to make sure that we're still stating that any type of work product that is created on work time still belongs to the employer. This can get it's not really tricky for maybe a administrative assistant or a ministry, a head of a ministry who's creating some type of document or something like that. But this can really become tricky, Bob, when we have clients that are writing music, that are creating online content and those types of things. We want to make sure that you specifically state that that property or that product that is created for work on work period belongs to the employer or the ministry. Is that correct, Bob?
I definitely agree with that. And confidentiality, I think you alluded to or mentioned a few minutes ago, is very important as well. Oftentimes, if somebody is working on a computer at home, you've got other people around, you've got other people perhaps even using the same computer. It's going to be very important for people who telecommute to keep in mind that their work time is strictly work time, that the content that they are working on is still subject to the confidentiality considerations that it would be subjected to if they were in the office. So it's important to have passwords as needed to protect that confidentiality. Another question that comes up, Leslie, or we've been asked too, is what about workers' compensation? Clearly, when we are in the office, we're covered by workers' compensation. Now, we are not in any way insurance or providing insurance advice on this particular program, and we're not here to interpret insurance policies or anything like that at all. Generally speaking, though, an employer that has workers' compensation that covers employees has those employees covered regardless of where it is that they are working. All right. So
Right.
if the employee is in the office working, they're covered. If the employee is at a particular location working, they are covered. If they are at home working, then they are covered during the time that they are working. So clearly, if you're working in the morning at your desk, you would be covered by the workers' compensation. If you decide to take a break and go outside and mow the lawn, well, you're no longer working, uh, and the workers' compensation insurance couldn't cover you. Would you be injured while you're mowing your lawn? So you need to keep in mind that the concept with workers' compensation insurance generally is it covers your employees when they are working. But because we're talking to people in different states, there are different specific rules with regard to when the work starts and when the work stops. So the insurance companies have to comply with the rules that are applicable to that specific state. So if you have particular questions about that, I'm certain that you can either speak with your broker or contact the insurance board. I'm sure they'll be happy to help you with that.
Awesome. I just wanted to remind everybody, use the chat feature. We would love to answer your questions, and we're excited to do so. Before we wrap up here, there's two things we wanted to cover, Bob. One was maintaining staff that are on leaves, or the whole leave situation, and also what happens if you have somebody diagnosed with COVID-19. So would you mind doing the staffs and the leave, maintaining staff on leave?
Sure. You know, Generally speaking, before COVID-19 came along, people being out on leave could be out on leave in any number of ways. They could be out on leave because they are sick and the employer has a sick pay policy. So they're only out for a very short period of time because they're sick. They could have state mandated sick time off. They could have an employer leave policy for longer periods of time. And of course, they could fall under FMLA and be off on an extended leave under FMLA. Now we have the emergency FMLA and the emergency sick leave policy. And we want to mention these only very briefly because I know each of these was covered by other webinars that were put on by the insurance board. And I would strongly encourage you to take a look at those and make sure that you're very familiar with those. Generally speaking, with respect to the paid sick leave, that the emergency paid sick leave that Congress just passed, it is for a duration of 80 hours. And there are 6 different criteria, one or more of which need to be met in order for that to come into play. So you definitely want to become familiar with those. The first criteria is that an employee is under a quarantine or an isolation order issued by the federal, state, or local government. Secondly, that the employee has been advised by a health care provider to self-quarantine. The third criteria is that an employee has symptoms of COVID-19. Those are the first 3 criteria. The second 3 have to do with care for someone else. The fourth criteria is that the employee is caring for an individual who is subject to one of the first 3 items that I just mentioned, or that the employee needs to care from a child whose school or place of care has been closed because of COVID-19. We're seeing a lot of that. I'm sure you are as well, aren't you, Leslie?
I am.
Okay. And the last criteria is that the employee is experiencing some other condition that's going to be specified by the Secretary of Health and Human Services. Don't know what those are yet. I haven't seen them. I'm not sure if those are out. So there are specific criteria that need to be met under this emergency paid sick leave act. And generally speaking, too, the emergency paid sick leave provisions trump or go into place before any state sick leave policy or the employer's sick leave policy. So for individuals who are out for a longer period of time, that would normally go out on regular FMLA, the Family Medical Leave Act, now have the possibility of being eligible for going out under the Emergency Family Medical Leave Act. But there is only one specific criteria that allows somebody to take advantage of the Emergency Family Medical Leave Act that is paid while they are gone. Is that correct, Leslie?
Yes, it is, Bob. In fact, the only reason you can take EFMLA and get paid for it has to do with children. Is that correct?
That is correct, Leslie. It has to do with individuals who need to take that time for purposes of caring for a child whose school is closed or their place of care has been closed because of COVID-19. We don't want to get too far into this, Leslie, because I know that the insurance board has other programs that describe this, a webcast that describes it in detail. And I want to strongly encourage everybody to listen to that and go over all the criteria for that, including the rates of pay that are applicable for those paid leaves.
Awesome. We've been talking about employees on leave, and we also have employees that are what we call laid off, and we have employees that are furloughed. And Bob, can you just explain that? That's kind of confusing in our world. What's a layoff? What's a furlough? How do we go about all that?
Well, a layoff, generally speaking, is the termination of employment. It's effectively terminating someone's employment because of lack of work that's available for them to do. A furlough is a little bit different. It's somewhat of semantics. It is a layoff with an expectation that it will be short term, with an expectation that the employee is going to be returning to work. So the expectations are a little bit different. The other things about a furlough that are somewhat different, and they vary from state to state, is that in some places, an individual who is on furlough can still maintain their employee benefits. You want to check with your benefits provider and see if that is possible in order for you to do that. Now, one of the big distinctions that an HR professional needs to keep in mind when you're deciding whether or not you are going to furlough or lay someone off is that under certain circumstances in some states, such as ours, an individual who is going to be furloughed for a period of time that exceeds a one pay period is going to be entitled to have all of their vacation or PTO time paid out. So if that furloughed employee is not going to be returning to work within the same pay period, then you are going to have to pay out all of that individual's current bank of vacation time and their PTO time. So before you just tell employees that we're going to furlough you and assume that we're going to call them back, you may be in a position where you are also required to pay out some of their vacation or PTO time. And when we're talking about ministries looking to reduce costs, the payout for vacation or PTO for a lot of people could be very expensive. And also we need to keep in mind that if the benefits provider will allow you to keep furloughed people on the benefits plan, there may be costs associated with that as well. So all of these cost factors need to be taken into consideration as to whether or not the ministry is going to do a layoff or whether they're going to do a furlough.
Awesome. Well, Bob, now we come to a really important topic that talks about if somebody is diagnosed on your staff with COVID-19 or coronavirus, as we're calling it. And I think it's really important that the employer know a couple of things. One is that if you have somebody that has been tested and they test positive for coronavirus, you do have to do a couple of things. You have to, one, notify your public health officer in the county or the city in which you live. Additionally, you have to notify your staff if at any point your staff would have come in contact with this person. And what I always recommend that you do is you let them know that you had a team member, a staff team member that tested positive, that hopefully it's your first case of someone on your staff involving COVID-19 that's been diagnosed. And you want to also let them know if that person was on your premises. And if so, you want to notice your employees that they need to seek physician assistance or guidance in how to care for themselves in the potential exposure. And that you want them to know that if there's any questions, they can contact you. And actually, Bob and I have created a sample notice, and that will be available to you on the Insurance Board's website as well. And if you have any more questions, we'd love it if you keep using our chat feature. And I think that this is scary for people. I think noticing people that somebody's been exposed to this virus and that they've tested positive is scary. But what we want to do is we want to make our letter calm and succinct, and we want to make sure that we're giving the information that is needed, and that we want to refer those people to their physician because you're not a physician. And then I always like to just remind people in this environment at the very end of the letter, please wash your hands. Please continue to wear your masks if you're required to wear them, and continue to do social distancing. Do you have anything to add to that, Bob?
Yes, I just want to echo what you said too, Leslie. I think it's very important during this time to recognize that if we do have somebody who is on our staff or has been in our building that is diagnosed with COVID-19 or has symptoms of it, we certainly want to get the message out there, but we don't want to violate that individual's privacy. We don't want to create any sort of a panic. But we want to notify individuals that if they have any symptoms or that they have any concerns, that they go directly to their healthcare provider, and that will be the quickest way for them to get accurate information with respect to their own safety.
So, Bob, you wouldn't want to say, hey, Leslie came into the building and she got sick and she's super sick right now and she exposed everybody there. And we all think you're going to get sick now, too. So make sure you run to your doctor. That wouldn't be good.
No, that definitely wouldn't be good. The sample notice that we'll be providing essentially says that we've received information that someone who was on the premises or in the building, if there are multiple buildings, you would identify which building on such and such a date may have been exposed to COVID-19. We are letting you know because the concern overriding is for the health and well-being of all of our staff, and we want to make sure that we are looking out for your best interest to the best that we can. And we would strongly recommend that if you have questions, that if you have concerns, and certainly if you have any symptoms, that you seek the care of your healthcare provider immediately.
I don't have anything else to add to that, Bob. I think that was great. We covered some great topics. I'm super excited to be here and to be able to help ministries as they move forward and navigate this really quite unique time that we're in. So I just wanted to thank you for allowing me to be on here with you.
Well, I certainly have enjoyed it too, Leslie. And one of the things that we're going to be looking at, hopefully down the road in the not too distant future, is returning people to work.
Oh,
And we can talk more about that as it goes on. But that certainly is something that we're looking forward to talking about, and the process that we'll go through in order to do that. And certainly that plays into one of the things that we just talked about a moment ago. You had asked me about the difference between layoffs and furloughs. And I'll just mention very briefly that if individuals are laid off, in most jurisdictions, that is effectively a termination or separation from employment. So when we return people to work, we have the option then of interviewing for a particular position that is open. The individual who worked in that position before may or may not apply. They may or may not be the best candidate for the job. If someone is furloughed, then there is an expectation that when the job comes available again, that work comes available, that they're going back into either the same job or a very similar job. In any event, that's something that I think we're all going to be looking forward to here in the future, and as we restaff once this pandemic is behind us. But again, I'd like to thank the Insurance Board for inviting us to speak to you today. And we certainly wish the very best for you. I hope everybody had a very wonderful Easter. And I hope that we're back into ministry as usual here in the very near future. Thank you very much.